16 CCR related to prescription drug take-back programs. The 45-day comment period began on February 12th and ended on March 28th, 2016. 2 regulation hearings were held on April 13th, one in Southern California and one in Northern California. At the April 2016 board meeting, the board approved a modified text to address concerns expressed during the initial 45-day comment period and also provided at the regulation hearing. A 15-day comment period began on May 3rd and ended May 18th, 2016. The board received several comments during the 15-day comment period. At today's meeting, the board will have the opportunity to discuss the regulation, the public comments received, and determine what course of action we wish to pursue. Among the options are: 1, adopt the regulation that was approved at the April 2016 board meeting. 2, amend the regulation to address the concerns expressed by the stakeholders and notice the modified text for a second 15-day comment period. 3, return the regulation to the Enforcement Committee for further discussion. And I'm going to add a number 4, which is what I'm recommending is that we go over the public comments, determine policy on some of the high-level policy comments we received, and ask the board staff to take that policy decision, rework the language, and bring it back to the July committee. So that's the 4th option, unless anyone else has any other options they'd like to put on the table. Greg, sorry, Jenny?
I was just going to say, after you get through going through the comments that were submitted, the board may have additional steps it wants to do, at which point you can do that. But the first step is to do this.
Good point. Good, very good point.
Which one are we starting?
We're starting with, I'm recommending we start with yeah, well, we start with attachment 2, which is basically going over the public comments so that we really understand them, and we've got public in the room in case there needs any clarification. There's staff recommendations listed on here, but I don't believe the board has yet reviewed this and made a decision from a policy perspective as to all of the comments that were provided by the public.
Okay, so, but my curiosity is that we have different iterations of the same proposal. Are we starting with our April 25th iteration, or 531, or 6/7?
The April 25th version was released for public comment. The grid that we're going to go through are comments on the April 25th version.
Perfect. Thank you.
So that's where we're going to basically go from there. And the attachments that are included are the staff recommendations, which we just talked about, which is this attachment 2, which is the 15-day comment table and staff recommendations, the comments received by section number, the modified text as noticed, and we're going to go based on the one that was approved by the board on April 27th.
Yeah, that's
25th, okay. And the comments, and then we're going to go review the 15-day comments. There's also some letters from Alameda, San Mateo, San Francisco, Marin, and Santa Clara County supervisors that is also included in the packet. And a comment received during the 45-day comment period that was inadvertently excluded from the April 2016 board meeting materials. And who was that from, Lori? The one that was inadvertently excluded? It was the one we recently received? I think I remember seeing that one. Okay, but it's in the packet now. Okay, perfect. Yeah, I think it's in the binder we received. I think it's actually, you segregated it, yeah, as the one in the back that was actually received, inadvertently omitted. Okay, so how does that sound? Or does anybody have an opinion on how we should move forward? Does it sound okay to go through the policy and go over the public comments? And I know we have a number of people. How many people in the audience plan on providing public input? Can you raise your hands? Okay, so we're just to figure out how to.
20 to 25.
Yeah, so we'll probably have to limit it to probably 5 minutes.
Okay.
Less than that, 2 minutes, yeah, because we don't have, well, it won't have much time.
Laura, you're going to be our timekeeper?
Do you want to go through the comments that we've received, or do we want to have the people that are here come first and provide their input?
I would suggest that you go through all the comments for a specific section or subsection, depending on.
And then get the public
And
comment?
then ask for the
Good
public
idea.
comments. And then, for those of you that are questioning, there was a document in the back that's a discussion draft that was prepared by staff, too. That isn't going to be discussed right now. We're going to go through the comments one by one, or section by section.
So
is
we're
probably
working
better.
off of the last, which is attachment 1, which is the modified text. Is that what we're working off of? Is that what you have too?
Attachment
Okay.
2. Oh,
Okay,
yeah,
when I look at the
yeah, yeah, yeah,
numbers,
yeah.
okay.
This is attachment 3 was the original April
That's correct.
25th.
So it's attachment 3?
The one
Okay.
you have is 531.
No, attachment 2 is this,
Yeah, but we're talking,
attachment 3 is this.
Okay.
And you're using,
Yeah, but in terms of referring to the numbers, to, like when we refer to 1776, which attachment are we using?
we're not using that.
3?
one.
Okay.
We're using this one, which is,
April 25th, okay, perfect. All right.
So just to be clear, so we're using the April 25th version
Right.
for this discussion, which on our case is attachment 3. I don't know how it was handed out in the back there. Was it also attachment 3 in the back, so people coming in, that's what they would?
There were some, no, what's in the back is a discussion draft that doesn't have anything to do with this per se. It was an advancement synthesizing the comments we've received to date. Instead, we're going to go through these one by one so that the board can
Right.
specifically either specify in or out on the proposed.
So though, if the public wants to follow this discussion, then they need to look at the April version that was posted.
Yes.
That's what we're talking.
Attachment 3.
We're talking, yeah, for us, it's attachment 3. For them, it's not.
Yeah,
Oh, it
it's in
is.
the
For them it
packet.
is.
It's in the packet.
It's in the
Okay, so
packet
everybody
online.
has attachment 3 is what we're going to be talking about. Okay.
And if not, you can check online if you've got a tablet or such that you can access it as well.
yeah, because this is, I think it's a good idea, Amy, because Ramon, this is what has been posted for the public.
Absolutely. Yeah,
Yes.
that's, I'm sure that's what we want to discuss.
Okay, so let's start off on the first page, and we start off with 1776. And we've got various, and maybe we should just do it by code section, so that we can look at them in lump sums. So 1776, there's a number of comments. Some of them are asking us to remove the list of drugs that are specified, and I think that's in 17.6.1D, where there is a list of agents that are prohibited from collection in the prescription drug take-back bin. And we have on there medical sharps and needles, iodine-containing medications, mercury-containing thermometers, radiopharmaceuticals, antineoplastics, cancer, cytotoxic, compressed cylinders, or aerosols.
This is actually in part of 1776. It's the second paragraph.
Yeah, I'm going by the attachment 3.
Okay.
Since
flip
we're
it
all
back-
going on
flip
the
it-
same
Flip it
thing.
back to a page. You're on the wrong code section.
On the wrong one? Okay. All right, there we
So,
go,
once
sorry.
you're on that code section
Okay,
right there.
thank you. Okay, so it's the second paragraph in 1776. So the comments were that we should remove medications, specific drugs from this list, with the understanding that the public is not going to know what these are. And it may prohibit pharmacies from participating, there's concern because of this language. And they go beyond the DEA regulations. So any board member comments regarding that recommendation?
So I would be in favor of that. I mean, I think there had been some discussion that maybe we could, remove all of that iodine-containing medications, mercury-containing, I mean, we just can kind of remove all that.
Do
And
we
that would
move-
include the chemo drugs.
Do we remove medical sharps and needles?
That's a good question.
We should,
Pardon me?
We want you to use your mic so we can hear you.
I would leave in the sharps and needles. Everybody knows what that is.
it's a drug take back, so I don't think.
Yeah, we don't
should-
want them in
We
there.
don't want them being in there.
Right.
Okay. So if we just say the following in pharmaceutical take-back receptacles, just say medical sharps and needles, e.g. insulin syringes, and leave it there.
Right,
Everything
And
else
take
comes-
everything else out.
correct.
Hey,
Thermometers, radiopharmaceuticals,
yeah.
So let me ask you, what would be the threat, I'm sorry.
Oh, no, I'm sorry, I'm go back on the first paragraph. It say, only the pharmacy and hospital clinic allowed to having this receptacle. How about like in Alameda County, we have, I'm sure in San Francisco too, as I understand, they have it now, that those non-pharmacy, like the one we have right next to my location, East Bay Mud Building. And I think they have on the federal building downtown Oakland, they have it. So are you go eliminate those?
But we don't
Not under our
license them.
control, because they're not under a
So
pharmacy.
they can have them, we're only talking about if a pharmacy has them, that these are the rules if a pharmacy
We only
has 'em.
control the one in the pharmacy only, so
Right.
the one they have out there is not under our jurisdiction.
They're usually under law enforcement,
Correct.
right?
Well, it's the East Bay Mud, so,
I don't, my understanding is the DA regulations don't touch the law enforcement.
But he's asking about us, so it's not under our
We don't
jurisdiction.
have control over
So-
the collection bin in
yeah.
Alameda.
So
County.
we will be, allow them to continue to have it.
We're not allowing them, we're not involved. We just flat out are not involved in those collection bins.
It's out of our jurisdiction.
Exactly.
So Amy, let's go, because is that make it more confusing to have medical sharps? So all board license collectors should be vigilant to prevent the public from depositing of prohibited items to the drug take-back, federal blah, 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 following in the federal take-back receptacles, and it's only medical sharps and needles. Do we have any idea how, is that an issue?
Well, I think there were some comments in here also about the use of the word vigilant, and what does that mean? Because vigilant implies that you're going to be actually reviewing.
Yeah, I mean.
Are
so
you,
I- I would-
are
I
you
would-
leaning towards taking this whole thing out?
Well, I guess I would agree with the word vigilant is kind of a lot, but I was thinking, yeah, that maybe even medical sharps and needles, the simpler we make it, the easier it is to enact and people to follow. But, if there's a problem with needles and sharps, then I don't want to take that out. But
Heard there is a problem. People were telling us that they were getting sharps and
I would add, though, in this particular case, I'm not sure in section 1776, we need the specific comment. I mean, the specific prohibition or statement. It can be better placed, and in fact, it occurs two other places in the reg. And so we can
Yeah,
fix
you're
it there
right.
and pull it out here. 1776 was intended to be kind of an overview, and what's missing in here is the drug mailback program that once was in there and we pulled it out. So that is definitely an option for pharmacies that want to provide drug take-back services to offer mail-back envelopes. So I think we might want to consider putting that back in, moving this and keeping, if the board so chooses, the medical and needles as prohibited items going into the bin
that's fine.
down the road.
But it says specified prescription drug take-back services. It does, in the first paragraph, it doesn't say bins. Doesn't that services include the envelopes?
Yes, that's what I'm saying. We need to add that back in. It got inadvertently removed.
But it's not in, the version I'm looking at is in there. The first paragraph?
But it doesn't say anything about envelopes anywhere in the section any longer. It got removed at some point.
Service, take-back services.
But isn't that global enough to
Doesn't
include
define
both?
it.
Not when we're talking about collection bins in the second paragraph.
So are you saying, Amy, maybe services such as drug take-back bins or mail envelopes, just kind of keep it?
Right. That
Keep it
makes
very
sense.
high level,
Yeah.
so. And then what you're advocating, Debbie, is just to remove that second paragraph?
That was my idea.
Oh, your idea?
Debbie-
Sorry.
Debbie didn't
Sorry.
go quite that
Yeah,
far.
I wasn't going, but I'm probably okay with that, too. I mean, I agree with that we want to spell out the two services, drug take-back and envelopes. Yeah, and if Jenny, you're right, I remember seeing the list
Yeah,
of drugs
I
like
saw it in two
throughout.
other places.
So, yeah, I would
It's
be
in two
okay
other
if you wanted to
places.
just take out the whole paragraph, then we
Okay.
kind of solve a couple of comments here.
Now, did you take out paragraph 2?
Yeah.
Well,
You haven't changed paragraph 1?
No,
All right,
I'm
do we-
adding, after take-back services, I was suggesting
Define.
such as
Such as receptacles
receptacles
and
and
mailback.
mailback envelopes.
Lord, do we need a
Collection-
motion on
collection
every one of these?
receptacles
I-
such,
I had a question. I noticed that those receptacle, people just walk in there and you drop it off. But if you restrict this, restrict that, who go be monitored, who go restricting them? I mean, most the patient, since they take back, they got dump everything in there. So who go prevent them from doing that?
The DEA has kind of an interesting policy on this. They require it to be within the line-eye view of the pharmacy staff, but not behind or in the licensed premises of the pharmacy. Outside that, because the individuals themselves have to drop it in. But we recognize, and that was what many of the comments were, the pharmacy staff isn't going to be there to review it as it goes in. So you need to recognize you're going to end up with stuff in there that perhaps shouldn't be in there. I think that's the reality of what we're dealing with. Unless it goes through the pharmacist on the way in, which was never a proposal, no, that was never part of the proposal.
But I think if we take that out, Albert, we won't have to worry about who's watching, because we're going to take out the fact about people being vigilant.
But what I'm saying, eventually, you're gonna end up with all this junk. I mean, everything they want to throw, they gonna throw in.
Yeah, but you know.
That what happens in Alameda?
I'm sure that
But
is,
you know,
but nobody
you know
go
what, you're not
watch
going to
it.
deal with it, Albert, because, you know, we just seal up the box and mail it. So yes, the reverse distributors, and I'm sorry if you guys are in the audience and I'm
They
looking
got
at it this
stuck with
way,
it.
but it's their problem.
Yes. I mean, if you, as long as we understand that, but what I'm saying is that you're not gonna prevent those patients what they got dump
I
in there.
agree with you 100%.
Now, Laura, do we need a motion on all of the changes?
I think as long as we keep track of the
Okay.
direction that we're going on each item, we can go over each at the end, as long as you have consensus. Because if,
We
well, it
could have-
depends
we
on, what
could
it
have a lot
depends
of
on what you
changes.
decide to do. If you decide to move the language today, then we'll need revisions. If you're deciding basically that we're going to make these changes and we're going to bring a revised draft back to the board in July, then I think that direction to staff, because come July, you'll
okay.
be approving the revised version for notice.
Maybe we should make sure everyone's okay with that direction. Are we going to review policy today, give direction to the staff, and review a revised for July?
Yes.
that would be my,
I think then we
You
can
want,
get,
you
then
want
we
a
can get
motion
it,
for that?
then we can post it and have
I'll make
plenty.
a motion. if that's what we'll
One
do.
more question.
Yes.
So since it's regulation, if it happen, if somebody have all this prohibited item thrown in there, the pharmacy will not be penalized for it.
No,
Oh.
first of all, I don't know, one, how we would know it's in there, because
Yeah.
no one's supposed to be looking
Yeah,
at it,
okay.
opening the bag,
Right.
inventorying or doing anything. If someone gets injured because of something in there, I'm sure the report's going to reach us, and at some point, if we get a lot of reports of that, the board's going to have to determine whether something needs to be modified.
Yeah, but they should
But at
not be
this stage-
penalized for it.
No, it wouldn't be, if a consumer puts something that shouldn't be in there,
Who are you concerned is going to penalize them?
Well, if I have a receptacle in my pharmacy, and if all this thing end up in the receptacle, they say, oh, you break the law, it's
not your
not supposed
fault.
to be going
Not your
there.
fault.
If-
Okay, that's why I'm wanna.
If it appears that somebody's putting like machine guns or God knows what else into the slot, assuming they could get it in there.
Where did
and the
that come
pharmacy-
from, Jenny?
I'm coming with something highly unusual.
Or
that you wouldn't
bombs
expect.
or something.
Who knows what could go in there? I really shouldn't, I'm surprised my attorneys let me get away with that. A statement that, oh yeah, we're not prosecuting. There may be some point at which heightened negligence to the point that
Okay.
something untoward occurs could force us into it. But one, we'd have to know it was in there in the first place, which already creates a problem.
There's already a fair amount of experience with these. I mean, I've seen the one in San Francisco. It's in plain view of the pharmacist. There is a sign on it in Chinese. It says, "Don't put your garbage in here," because I'm sure
You know
that's
that.
been a problem.
Wait, did it
And-
say, and your machine guns, don't put those in there either?
They didn't mention machine guns,
It off the wall,
but there's
okay?
already considerable experience with this. And, you know, it's not, I don't think any pharmacist has gotten in trouble in San Francisco because what wound up in that bin.
There are issues that could be related to this that could cause a problem for a pharmacy with the board, however, in terms of how that collection bin is maintained. So you can't totally say whatever goes on in the box is a.
Right, but that's not, the
I mean,
subject we're on right now is what goes in the bin. That's the amendment we're dealing with.
Yes.
And I think it's a great question. I'm glad we got it out there, Albert,
Good.
so thanks.
Just one thing, while we're talking about it going to staff and then returning it to us, it's my hope that it goes to staff, and when it comes back to us, it'll refer to the April 25th document that we're working with, and what comes back to us will be blue-lined what we're taking out, red-lined what we're putting in,
Yes.
good. Thank you.
And that's your motion, right?
That's my motion.
Second.
I think it already was.
Okay, any public comment regarding the motion, which is that we will discuss policy decisions today, have staff take back the policy decisions, rework the language, and bring it to the July meeting? Okay.
That's
all
the
in-
motion, is the process?
That's a motion, and there was a second.
Sure.
I was just explaining to the public
Right.
what the motion was, because we'd had a lot of discussion between then.
Public would want that because this way.
Yeah.
But also, the public should know it matters that they're here now.
Exactly.
Yes.
Well, and then also then they can look at it and hopefully we'll get it out to them
Okay.
with
It won't
plenty of
probably
time
happen
ahead of
until,
time.
it probably won't happen until after the July board meeting, because you're going to have a chance to look at it at the July board meeting. Unless
In,
it'll
in,
be-
in advance of the July board meeting.
In advance
We'll
of
get it out in
July- oh, I see what you're
significant
saying, yeah.
time
We'll look
to
at it
review
in
it.
advance.
Okay.
Right, yeah, so next time,
Yeah.
you're right, this will be out 10 days ahead of time, and whatever it is out 10 days ahead of time
That's
is
the
what.
agenda, hold on, that's the agenda, but the language will be done well in advance, because we're going to.
Right, yeah, I think in deference to, many of the people concerned, we should try to get the language out in time for people to have a few days to look at it.
Yes, that is the goal, Ramon.
Good.
Hi, my name is C.T. Weber. I'm with the Carroll Legislative Committee.
Mr. Weber, is that
yes.
right? Yes.
Correct.
Good afternoon.
1B. My only concern was, what we have here is the June. We don't have the April document that you're working from, so we just let you know that, and I don't know if this is in play or not, so this is the
Well,
one that was
it's
on the
online.
table.
It's online, but the April one's online, but what we've decided is we're not going to be considering this June version.
Okay.
We're going to instead, because that June version assumed that all the staff recommendations would be approved, we're going to have a policy decision today on all the various items. So if you hear something that you believe you would like to have input on, please speak up when the public comment opens up.
Well, and I think Laurel is actually now distributing the April language, is that correct?
Yes.
Oh, thank you.
Okay, yeah, so
There,
that's what I was
yeah.
trying to get clarified before, is do people have the April language?
I'm going to call for the vote, please.
Yes.
Okay, but I mean in the room.
Okay, all in favor? Okay.
Thank you.
All right. Anything else on 1776? That's all I saw by looking at that first page.
So we're striking the second paragraph.
Yeah, we're striking the second, and then we're also going to be adding, define the take-back services with such as, and list.
Collection receptacles
Yeah.
and mailbag bags or something.
I have
Yeah, I'm
one
taking
more.
very detailed notes, so I make sure we review them afterwards.
I have one more thing. Since I'm the author of the discussion draft in the back, one of the things we don't talk about in here is reverse distributors. And so I added one paragraph in to just provide an overview, which is what this was intended as, that reverse distributors are the entities that are going to end up with the removed liners.
Where is that?
That is not there. What I'm doing is looking at the discussion draft.
Well, let's stick with the April one. If
Okay,
Yeah, let's,
okay.
we'll stick with this and then just move on. So at the first page, anything else on 1776? Otherwise, let's go on to the next page, which is 1776.1.
Were there any more comments?
Are there any
1776?
public comments on 1776?
we're dropping the second paragraph.
Yeah, dropping the second paragraph and adding a definition of what pharmaceutical drug take-back services means. No, okay. Moving on to 1776.1. This is going into the section that's entitled pharmacies. So if you, can you review those and see, let's start out with let's do the first page first. So there's a comment from Anthony Riley, Kaiser, and CHA. So CHA is saying they want to reiterate their position of non-mandatory participation. Kaiser actually asked the same. And Dr. Riley wants mandatory to be placed into place. So I think the board has elected to stay silent on that. For the regulations, is that the continued direction from the board?
Well, we sort
Well-
of say silent because.
Yeah, we don't want to preempt.
Because, yeah, we don't want to preempt, so we took out the reference to non-mandatory, but we also say in here
I think this is
may.
referring to A. We're really, right now, we're focusing on 1776.1A, which we had deleted in the April section, where it says provision of such services is voluntary.
Wait, now, where is that?
Right here on the top of-
1776.1A.
Okay, okay.
We had deleted it, but CHA is asking Ann Kaiser that we reconsider that.
State that it's
And
voluntary.
Anthony Riley, MD, is asking that we make it mandatory.
Well, and we had discussed this at great length in April, correct?
Right. No, we're just, going
Right.
through
Acknowledging the
these and
comments.
acknowledging
All right.
the comments. And right now, the board staff has put reject on all three. And basically, the board is not making participation mandatory, and we support voluntary participation, but it's not our intention to preempt local jurisdiction.
Makes sense to me.
So we're taking A out.
Well, A is already out. We're just reaffirming that
Leaving it out.
because we've had some requests to put it back in.
And A says provision of such services is voluntary.
Yes.
But new A, I just want to be clear, new A says pharmacies may provide take-back services. So we're not, it's not quite, as in your face as the voluntary, but may still, yeah, I get it. I'm
I think
just
our
trying to
attorney
be
said that was
transparent and
permissive
say
language.
We have may in there.
Permissive,
Was
yeah.
that permissive language is what we
Yes,
heard last time,
right.
right?
That is correct. We do not believe that the use of may would have the same preemptive, potentially preemptive effect as the prior language
As the
using voluntary.
voluntary, right.
Thank you.
Okay, so is there any change in that direction from the board members?
No.
Dan?
This is an issue that has come up. Abdicating our ability to regulate what goes. Regulate.
Well, all we are saying is that where pharmacies are going to participate in drug take-back, these are the criteria and the protocols they have to follow in order to do so, which I think is the appropriate bailiwick of the Board of Pharmacy to say. The separate question as to whether those pharmacies will be required participants in product stewardship or, waste disposal, that may be an appropriate question for the localities to address, they can separately address by whether they mandate their participation in what is essentially a waste disposal scheme at the local level. Yeah. I don't think, you're really asking me a policy question, not a legal question. So you should decide whether you think by not controlling whether it is or is not mandatory, whether this board is inappropriately ceding control of that issue to others. That's a policy question. From a legal standpoint, you are remaining silent on whether this is mandatory or voluntary.
And we're maintaining control over what happens if there are kiosks.
Right, if they do it, they have to do it according to not only the DEA's standards for controlled substances, but also your standards for all other drugs.
I mean, there's tobacco, there's alcohol, there's even selling. Pharmacies.
Well, I mean, as an example, I think tobacco is actually a good example,
is.
which is that there are localities that are trying to prevent pharmacies from being involved in the sale of tobacco. So that's not something in which this board has yet become involved.
I thought
So-
we did make a decision last year, didn't we?
We made a policy
Thought
that
so.
healthcare should not be
Right.
provided in a facility that's selling cigarettes.
Right, but I mean, as, in terms of, we don't have any, currently
that's
have
a
any
should.
statute or regulation
Yeah, that's
to,
correct.
to impose that policy. And so what I mean is, as a legal matter, that field remains open to localities or the state or whatever to make that to make that policy somehow.
San Francisco banned sale of tobacco products in pharmacies 8 years ago, and we've been okay with it.
So what you're saying is an entity, an organization can decide to do it or not, and our policy statement is just saying what we believe is the right thing.
What you are doing is consistent with what the board typically does as we just saw with the automated drug delivery systems, which is if you are going to do this, this is the way in which you have to do it. That's typically the way that this board has regulated pharmacy. There obviously are some things that the board does mandate that you have to do, but it also has many areas of pharmacy practice where it says, compounding is another example. You don't have to do it, but if you're going to do it, this is how you have to do it.
Amy, I have a question. So it's not, we've kind of spent time on this, and, the May, I think, makes it somewhat permissive, but aren't there kind of two things we could do here, Laura and Josh, and that is, we could handle it as we have in this document, but then we could also have a policy statement, if we wanted to, that kind of goes along with even the staff recommendations, that while the board supports local participation, that we support local participation, but we don't mandate, and we don't think it should be mandated. I mean,
Well,
Is there such a
I
thing?
always am hesitant where you make policy statements that infringe upon or might be taken as statements of law, because, or that might be taken as interpretation of your regulation, because then you're getting very close to having what's called an underground regulation. If you're saying the regulation says this, but what it really means is this, that's an underground regulation. So we'd have to be very careful about any kind of policy statement like that.
But at some point, you will make your decision about whether or not to respond to the comments. You know what I mean? And
okay, so I have another question then. Let's say somebody mandates pharmacies to have drug receptacles, then this is the policy of the mandate, which also allows for situations where, as we currently have written, I know we're going to be discussing it, but as we currently have written, that the PIC can make a decision, it doesn't work in my pharmacy, or if the PIC or the pharmacy has had probation, that it wouldn't be in those facilities also. So by having these regulations, the counties or the cities, if they mandated, the pharmacies would still have to abide by these regulations.
Right, well, for that particular potential conflict between a local mandate and the board's regulations allowing for an opt-out, that's another area of potential preemption litigation. We don't honestly know whether a pharmacy in that circumstance would be able to rely on the board's regulations to say, notwithstanding the local mandate, I can opt out of this because my PIC does not believe it's safe or we're on probation. We believe it's more likely than not that, yes, it would have that preemptive effect, but this is not at all a clear area of law, and it's the kind of thing that would probably have to be litigated at some point to find out whether that pharmacy could in fact rely on the board's regulations as a means of opting out of a local mandate.
Well, I mean, it's not only the pharmacy wanting to opt out, but I think there's situations where the board really doesn't want to have a receptacle in some pharmacies.
Right, no,
because of that
I guess what I'm
probation.
saying is, Yeah, whether
I
it's.
mean, it's both ways,
Yeah,
yeah.
exactly. So it's quite
Okay.
possible that a pharmacy would want to do it, but would be on probation, and the board would say,
The board might
we don't
say,
want
no,
you
no, no,
doing
no,
it.
no.
Yeah, yeah.
But
Well,
wouldn't
and
wouldn't that be
then
a
we're regulating the pharmacist and his practice of pharmacy,
Right.
not the waste disposal laws of that jurisdiction.
But we
Right,
could-
but I think the point, Ramon, is that regardless of what this board thinks, or even what that pharmacy or pharmacist thinks, the local jurisdiction might say, we don't care that that pharmacy is on probation. They still have to be a receptacle. They
Well, I
might,
think we'd
they
win
might
that
say
one.
notwithstanding what the board says. I'm just saying that's a potential point of conflict.
And could we put it in the condition of probation as a condition?
Well, I don't think we need to if this regulation, I mean, you could, but that would be superfluous, I think.
Okay.
Yeah, if it's in the regulation, it would be prohibited.
If it stays in there.
Regulation itself, as it's written, would resolve it. You wouldn't need it.
Right, but like I'm saying, that would resolve it for the purposes of this board's jurisdiction. That wouldn't it would have to be, I think, probably decided in a court, whether, if the local decided to pursue this issue, if the local really pressed for making everyone participate, whether or not they're on probation, then the issue of whether either their probationary status or their PIC's decision to opt out could exempt them or, make them not subject to that local mandate, I think might have to be litigated.
Okay, thank you. All right, so are we okay with continuing with our current decision to delete A? Are we okay with moving forward with that? That's what I'm hearing? Okay, public comment? All right, moving on. 1776.1B, CHA recommended that local jurisdiction be removed. Right now, this is B, 1776.1B. It says there are multiple federal, state, and local requirements governing the collection. CHA is requesting that local be removed because their expertise may run counter to what is deemed appropriate by state and federal authorities. Staff is recommending to reject the comment because the DEA specifically states that all drug disposal sites must be conducted consistent with federal, state, and local laws. So are we okay with moving that rejection?
I'm okay with it.
Okay. The next one is a recommendation on C in that same area, 1776.1, that we add change consumer to consumer or personally lawfully entitled to dispose of the consumer's property. I mean, I think consumer is pretty broad anyway, but do we need to change that?
Well, this is like for family members, right? Is that what we're talking about? That was how I read it, was,
Yeah, but I don't think anyone's going to question somebody walking in with a bag and saying, "Are you a consumer?" I think that's just being a little too detailed, is my personal opinion of this. Yeah.
I suppose whoever drops it in there, drops it in there. Okay.
So do we want to just reject that comment?
Yeah.
Okay. And then D, the numbers D below it are regarding removing, again, the drugs. Remember, we talked about it in the beginning. So here, we want to do the same thing. So we want to eliminate D? Or do we want to keep the signage? Because this is different because on the end of D, it says signage informing the public of the items prohibited from being deposited. Do we want to let them know they can't put sharps in there?
I think it's worthwhile that there's ever an issue.
Good point.
You didn't inform.
Yep.
Yeah.
So do you
Well,
want
I
it just
think-
for
So
sharps?
leave the signage in.
But I think that's
Sharps only.
different than the provision at the beginning saying it's prohibited, because the question is, if you're having a prohibition, A, are you going to enforce it, and B, how are you going to enforce it? If you want to just have a sign saying, don't put these things in, that's different than, I think, saying they're prohibited. I think you could just essentially flip the language here and say you should have a sign saying all of these things are prohibited without actually saying that they're prohibited, if you see what I'm saying.
Monitor it if you put up a sign is
No, I think it's just saying,
Right.
informing the public.
It's like that one in Chinatown. There's a sign that says, don't put your garbage in here, but people,
They throw garbage in.
right.
That if a pharmacist is watching the bin and just happens to be there and sees someone going in with needles, I think that they need to say, don't put these in. I mean, that's a little
Right,
different.
right, I agree.
That's, but it's not a duty to hover over the collection
Right,
bin
right.
and stop anything that might go in.
So that's good.
So the way it would say would be signage shall be posted informing the public of items prohibited. Now, are we just talking about sharps in terms of prohibited items? Is that what we decide to do?
Yeah, just sharps.
Just sharps?
So we're going to get rid of like the first, is
Yeah,
that one
the
long
fir-
sentence?
So it'll just say signage informing the public that sharps shall be prohibited from being deposited in collection receptacles. Okay. We're okay with that?
Oh.
All right, and then that goes along, we're done with the Kaiser comment, got resolved. The next one is 1761E2. There was a request that we clarify what other entities means, because it's too broad. Where it says, "A pharmacy shall not accept or possess prescription drugs returned to the pharmacy by skilled nursing homes, residential care homes, other facilities." What does other facilities mean in this context?
Anybody else? It could be that collection bin that's sitting in the state building. If somebody took the liner out and brought it to a pharmacy, they could not take that. It's another entity, and it's intended to be inclusive, so that the pharmacy doesn't become the collection receptacle for other entities that
But
might bring it
isn't there
to.
another part in here that says that? Above it, it says, dangerous drugs that have not been dispensed to consumers for use, such as outdated drug stock in a pharmacy, drug samples may not be collected as part of the take-back program.
That's already within the pharmacy. This is what could be brought into the pharmacy from outside.
Okay. You're good with language as it is? The board, everyone else okay with that?
Yeah,
Just
I'm
keep
okay with
other
that.
entities? Okay, so we're going to reject that one. Okay, the next one is from Serum. They requested that adding in a collection receptacle to the end of the section that pharmacies can continue to return non-collected prescription drugs from facilities or skilled nursing. So this is E2. So they want to say in a collection receptacle at the end of this. Because
Oh,
I
yeah,
think,
that's probably not a bad idea, because it says drug take-back programs.
because that
and
could
this is-
also, they
it
do their
could be the
own.
envelopes.
Yeah, well, I think, doesn't
This
Sarah do their
This
own?
section can include envelopes. It's
Yeah.
not just. it's
So
just-
you might want to put in, you might want to qualify that in 2, we're talking about collection receptacles.
Okay, so we want to put in
So we would accept
a
that.
collection receptacle. Okay.
Or any other form. They could bring it in a bag or something. I mean, it could be anything. It doesn't necessarily have to be in a collection receptacle.
I mean, I think in the pharmacy that they can't put it in, I'm referring to that as the pharmacy's collection receptacle.
Oh, I see.
Yeah.
Oh, okay.
Question? So the one in the skilled nursing home are not allowed to put in there. How about those, we have some problems sometimes with how about the doctor's sample supply, where they go disposed to? Where they
Law
normally?
enforcement. They go to law enforcement or they go to a reverse
Or they
distributor.
pay, they actually pay for that, so sometimes what'll happen is they think they can do this, so they don't have to pay a reverse distributor instead.
Pharmacies are not allowed to take back a physician's samples,
So they
period.
normally, where they go, it's, they say the law enforcement.
Or pay a vendor to do it. Vendors will come to, just like they come to your pharmacy to pick up outdated drugs. You can't throw it away, right?
Take away with it, yeah.
Yeah. Okay, anything else with the E2? The next one is 1776.1I from San Francisco. Commenter requested this section be removed as unnecessary.
Pharmacy cannot.
1I, which is which basically says a pharmacy shall not provide take-back services to consumers if it's in the, this is the PIC language.
Why don't they like it?
And Kaiser also said, they expressed concern that the pharmacy permit holder is not allowed to make participation decisions when they may face civil action. Kaiser recommended that the language be modified to allow the permit holder authority to make the decision. And who's the permit holder? in this
Kaiser itself.
situation, would this
Yeah,
be?
that'd be like
They're
the
talking about
corporation.
Kaiser, they're talking about.
So if I
Kaiser.
was Walgreens, I could make that decision. See, I think that's going to be a difficult one to put permit holder in there.
keep it the PIC.
Yeah, because PIC, the idea was maybe there's some special situation in a certain pharmacy where the PIC's judgment, could say that this is something to do, but we did not want to give a blanket waiver to any whole, pharmacy system to just say, nobody here has to do it, because then we basically gutted our own regulation.
Well, California Product Stewardship Council recommended that the section be removed as it allows for an exemption without having to justify it. Clean Water Action recommends the section be removed as it will discourage pharmacies from participating or they may confuse pharmacies. And San Luis Obispo Integrated Waste recommended changing if you look at section I, it says, as provided in section 1776 to 1776.4, that's very global, and it basically includes envelopes. So I don't think we can make I kind of agree with that. I don't think you can make a decision
that
that an envelope has a PIC decision to it, because there is no.
Okay, so you're saying that is drafted here, it's too broad.
Take
Yeah.
those code sections out, it doesn't do anything. but
Okay, so
confuse things.
best idea is to drop I.
Yeah.
Okay,
No,
No,
we're
not
not
drop
gonna, we're not
by.
gonna drop by.
Oh, no, to remove the code sections.
Yeah.
So a pharmacy shall not provide take-back services to consumers if, in the professional judgment of the pharmacist in charge, the pharmacy cannot comply with the provisions of this article.
That's good.
Do we want to change that, though, to allow mail back?
I like it
Because
just the way-
this,
I like
the way it reads with take-back services, it'll,
Because for whatever reason, we look at the pharmacist in charge as being the pharmacist in charge. And whether he doesn't want to carry controlled drugs because there's a problem, whether he doesn't want to do anything else that has that pharmacy area, this is the guy we look to control it, and this is the guy who's going to keep the area clean, whatever situation might be. And he's the one.
I agree.
Okay, so there's
well,
additional.
wait a minute, are there any pharmacies that don't carry controlled substances?
Oh, yes, you bet there are. And they don't carry them for a variety of reasons. And they don't carry them for a variety of reasons. And some of the reasons are that it attracts constant break-ins. And so there are many pharmacies in high-risk areas that they even post a sign, we don't have narcotics, we don't have controlled drugs, because of the dangers that it presents to the organization.
When we refer
Oh, go ahead, Ramon.
to, because you want to delete the phrase as provided in sections 1776/1776.4, what's the purpose of deleting that?
Doesn't add anything. It
Oh,
doesn't
you're
add
saying
anything.
it's redundant?
Superfluous.
Broad, it's making it
Okay.
way too broad.
Well, it also
Well, no,
addressed the
Debbie's saying something
it
different.
addressed the envelopes, and so what
It did
Stan's
address
saying-
the envelopes.
So-
Because included in that range are the envelopes. So we've now taken that out.
So then,
Talking about-
what we're saying is no pharmacist would be able to say, I'm not going to give you an envelope, because in my professional judgment, it's not a good idea. Is that how it would work out?
That'd be really hard for them to justify that.
No, it would be. I'm just trying to make clear that we could mandate that they have, or a county could mandate that they at least give people envelopes, and there's no good reason not to.
Or the board could change it to, as Lori was suggesting, a pharmacy shall not provide a collection receptacle if in the professional judgment of the pharmacist in charge, the pharmacy cannot comply. Still
Laura-
leaving the mail bag.
Laura and Josh, what do you think on that? I mean, what is if we take that out, what's the implication?
Well, you want me to go? Okay. I think it's the policy decision, but I think you've accurately identified the distinction. Take-back services is globally both functions. It includes mail back or a collection receptacle. The other one is if you make it specific to the collection receptacle, you're not being specific, and the preemption effect would not apply to mail back. So the pharmacist would have to explain the need for
So
mail back not being available.
the pharmacy board works with pharmacists in charge all the time, and it has certain expectations of the responsibilities that a pharmacist in charge should have and does have, And do you feel that giving the responsibility to a pharmacist in charge to make a decision about a collection receptacle or mailback falls within the realm of believability with regards to the responsibilities that you give pharmacists in charge in all other areas of pharmacy? Do you think they're capable enough to make that decision?
Yes, because I will tell you that if they do not do that, their license, they're putting their professional license on the line for the operations of what goes on in that pharmacy. So in the situation I alluded to earlier, where someone walks in with a machine gun and throws it in the slot, we could argue that the PIC to have control, now if the PIC was on vacation, it would be hard to blame the PIC, but if the PIC was at the counter and said, hey, you really shouldn't put that in there, and didn't, I don't know whether you'd want to have somebody arguing, don't put that machine gun in there. But there is a point at which you have to hold, our pharmacy law allows anyone to own a pharmacy, but only a pharmacist in charge is responsible for the operations of the pharmacy. And so this is entirely consistent for the PIC to be maintained. Not only is the pharmacist in charge responsible for the operations of the pharmacist in charge has to maintain oversight of that collection bin and be comfortable doing so because it's a public safety
But my
obligation of the
question
license.
goes, do you think after all the responsibilities that we give to these people and the expectations that we have to them, that we ought to allow them to make a decision about either a receptacle bin or a mail order bag?
I think that they, yes, I do.
And
Thank you.
just for members of the public, I wanted to just really quickly read the board's regulations regarding pharmacists in charge, and that's in 4036.5. Pharmacist in charge means a pharmacist proposed by a pharmacy and approved by the board as a supervisor or manager responsible for ensuring the pharmacy's compliance with all state and federal laws and regulations pertaining to the practice of pharmacy. So that's the board's expectations for a pharmacist in charge or a PIC. Mr. Weber, right?
Did you say 2 Bs or 1 B? 1 B.
Yes.
Thank you. I hate to bother you again. The way I read this now is that pharmacies can be off the hook for the take-back program altogether if and, you know, thousands of them could just back out of the program just because the pharmacist in charge says, we don't want to do it for some reason. And I think that weakens the whole program. And I had a mark by it that I thought that it should come out before this even came up, so sounds like something that's in the way that will undermine the whole program.
No, I don't think so. I mean, I see that Alameda County is doing it, and I see San Francisco is doing it, and I read about Walgreens implemented in their pharmacy. And if we have this kind of program, I probably want to have one in my pharmacy, but like I said, I don't like to say you have to do it, but I would like to do it for my customer, so I would want one in there. So, I mean, it's good public relation for us to have a receptacle there. And if I don't have one there, Walgreens have one, they're going to go to Walgreens.
Right.
So, I mean, I see what you're saying, but we don't like regulation, but sometimes that's needed. We have to have it, but we don't want to force them to do it if they don't want to do it.
No, I mean, they've already got a May in here. I mean, that's pretty voluntary already, and it just sounds like this is a way that pharmacists can just back out of the whole program. And
Well, to get back to Amy's point, what you want to do is just delete that phrase 1776 to 1776.4, and
make it broader?
no, actually, then it means that on the envelope thing, that we're not saying the PIC can say, I'm not going to hand out envelopes.
They would have to have a hard time saying that in their professional judgment, they can't comply. I mean, we hold in those, for members of the public, we hold our PICs to very high levels of standard. If there's a theft, for example, in the pharmacy, the pharmacist in charge is responsible. If the drugs, even though they weren't personally involved, we hold them accountable. So we provide a great degree of professional distinction and responsibility to that PIC. So that's where I think the board members are going, at least from our understanding of how that regulation is written.
I have two comments.
Yes.
The first one is, I think if what we're doing in I, we should duplicate and do in J also. And then the second thing, Ramon, I just want to be clear that by taking out 1776 to 1776.4, we're not saying that they have to do the envelope. Because it says the pharmacy shall not provide take-back services to the consumer, and take-back services is both the receptacle and the envelope.
Right,
Yeah, but they would need to justify
Well, either way. they
why
have
that's
to-
a
either way.
professional judgment
Either way, they
decision.
justify it. I'm just wanting to make sure you understand that we're not.
No, I understand it.
Okay.
But it'd be pretty hard to think of a reason why you wouldn't hand an envelope.
Okay, so that we are, now CRA expressed concern on this one. I just want to go over the other comments regarding I, that the justification to not have a receptacle creates a burdensome administrative process. They recommend that the board only require justifications for pharmacies subject to a local mandate. That's, I'm looking on, these pages aren't numbered, but it's 1776.1I, the CRA comment. I'm just going over all the other comments regarding the I so that we hear them all.
Are we I don't see where we're requiring paperwork here.
No.
I guess I'm trying to understand, and maybe Brian, you can help me. So if we, subject to local mandate, I guess I'm not understanding how adding the local mandate.
This is CRA. Angie.
Sorry, Angie, I'm sorry.
I'm sorry, I just didn't, I
Yeah,
couldn't
thank
figure
you,
out.
thank you.
I don't know how you can make a mistake between Angie and Brian, but.
Well,
That's a very difference. You're right. Good afternoon, Angie. Your microphone on.
Hi, good afternoon. I'm doing well, thank you.
Could you introduce yourself? I'm sorry.
Angie Minetti with the California Retailers Association. So, let me speak to that. I think there was some concern from our members that, with this PIC portion, there sort of is this gray area where would we have to document those decisions that our PICs would be making? Is that going to be something that is retained at all chain stores, given if there was some sort of documentation? And yes, you are correct, the regulations do not specify any requirement of that sort, but, I guess our folks weren't sure if there is some sort of official record
I think
made
it'd be
for
a very
that.
good practice. I mean, at least if there's ever anything that's questioned about a decision, at least you have some kind of documentation that you can point to and say, here it is, instead of, somebody shrugging their shoulders.
Some of the mandatory programs may ask for that as well.
Well, which is exactly why, most of our membership, even though it isn't required here, thought that, well, in order to ensure that, we are sort of clear as far as where some of our stores may be, where some of our stores may, may be participating or may not be participating, that's something that each of our members would have to sort of retain and maintain. And so I think we were maybe contemplating having that type of record keeping maybe for the stores and locations that are subject to some sort of, local ordinance, whether it is mandated or not, but, for those record keeping purposes. And we were just, I think we want to take this back to our membership too, to try and talk through what that process would look like for us. For example, with some of the ordinances as it relates to private label, there's sort of some counties allow for some sort of written paperwork trail for us to provide the manufacturers of our private label. And so there's sort of some documentation for us to point to so that we're not considered producers in these ordinances. And so, with that in mind and looking at this PIC provision, we're kind of wondering, well, what exactly would that look like for our pharmacies? at a statewide level and then also at a county level for those that are subject to local mandates. I mean, I don't have a,
You're saying if there is paperwork needed, that only be required if it's mandated
But-
at the local.
but I- but I-
That's up to
or
them.
if we're
They can do it
subject
voluntarily.
to.
Right, but
or if it's
I don't
subject
think
to
the
an
board,
ordinance.
I don't think a board inspector would go in, since we're basically saying may, ours permissive language. I'm not sure a board inspector would ever ask, I mean, correct me if I'm wrong, why aren't you doing it? Because our language is saying may, if it stays may.
What more likely could happen is that a community says that this particular store is not providing it. When I went in to ask why, they either wouldn't tell me or they gave me some ridiculous reason. Consequently, we think they're violating the local ordinance, and it would still probably go back
It
to
would be a local
ordinance.
ordinance, but I don't know, I don't think we would send a board inspector
I can't
out
imagine a
if it's-
situation
if
where we
it's
would, but I'm
may.
not
And it's
gonna
just
say we
dealing with the
wouldn't.
local.
So I think what you're asking is
Okay.
probably already built in, because I'm not sure the board would enforce any type of,
This is like patient consultation. If you want to
Yeah.
do some documentation that the patient failed to take consultation, we don't require you to document that. Many stores do. Same thing here. That's up to you how you handle that.
Okay, all right, we'll take that back.
thank you.
Thank you.
The other comment came from RX Safe Marin that says commenter recommended that mailers be pre-printed for postage because the public should not have to pay the postage.
Amy, can I interrupt you? That's 1776.2. So are we?
Oh, I apologize. Sorry, Debbie. I apologize. You're right. Okay. So we're done. Are we done with 1776.1? Is there
Public comment.
public comment on 1776.1?
Okay, you're going to be subject to 3 minutes, recognize.
No, we
Okay.
said 2 minutes.
2 minutes.
Oh,
2 minutes.
Yeah.
2 minutes.
Oh, talk fast.
So Lori Hensick, Kaiser Permanente. My comment is just to clarify, if to the extent that it may be needed, or to reiterate our request that the permit holder also be allowed to take place in the decision. Really, maybe it might even be a point of clarification, given the permit holder or owner is not permitted to be a deciding party, what then would be the resultant or consequence in terms of the ability for the board to hold the permit holder accountable if they are not allowed to then be a part of that decision?
We're not sure we're enforcing this, and if we do, we don't know how that would play out. The onus is on the pharmacist in charge to make the decision. It's not on the employer to make the decision for the pharmacist in charge.
Okay, so that, just a point that we wanted to make sure was duly noted. We're fine either way at that point. We just wanted to make sure it was clear where the responsibility or accountability lied for somebody who wasn't able to partake in that decision.
If the PIC then turns around and says the pharmacy holder wouldn't let me do it, or I was going to be fired,
Right, yeah. Okay, thank you.
Thank you. All right, moving on to 1776.2.
You got-
Oh, wait, we have another comment. Sorry.
I think we
I
got a couple.
apologize. Good afternoon.
Good afternoon. I am Tim Goncharoff with the County of Santa Cruz, and I know I just have a couple of minutes, so I'm going to try to be brief. We have the longest-running, most comprehensive, most successful Sharps and Drugs Take Back program, not only in California but in the nation. It has worked very well for 8 years. We have more than 40 locations. Last year, we collected over 27,000 pounds of drugs, over 10,000 pounds of Sharps. We have had not one single problem. I appreciate the comments about Section I and how pharmacists in charge must use their professional judgment on many important issues. However, I think you're taking this unintentionally into uncharted territories. I don't think ever before have you suggested that a pharmacist's professional judgment extends so far as ignoring local laws. You've already said elsewhere in these regulations, as has the DAA, that pharmacies will follow local laws. And now you're saying, but if in your professional judgment it's not a good idea, go ahead and ignore them. As your counsel has pointed out, you are putting pharmacists in an impossible position There will be litigation, there will be enforcement action. It's going to be a mess. Now, I would suggest that in the absence of a mandatory program, and many of the programs so far are voluntary, that Section I doesn't offer them anything they don't already have. But where there is a mandatory program, you are putting them in an impossible position. I would strongly urge you to strike Section I in its entirety. And I will remain here for a moment just in case there is a question for me.
Thank you.
Thank you.
Any other public comment regarding 1776.1I or J? Hello, Heidi.
Hi, how are you? This is Heidi Sanborn with the California Product Stewardship Council, and I just, when we go out to recruit bin hosts, I've never once had a pharmacist in a chain tell me that they could make the decision to host the bin. Every single time, they have to go to corporate. So this doesn't feel to me like, I understand, and I learned a lot today about the pharmacists that don't even carry, the controlled substances, et cetera, but it does seem like they really are not going to be, it's going to be more of the chain stores making the final decision, and we may not end up with as many bins as we would like. And so I just want to point that out, because we've never had a pharmacist in charge be able to host a bin.
So are
Not
you
once.
okay with the recommendation made by Kaiser that we add in the permit holder in there in addition to the PIC?
No, I just think we're getting way off the DEA regs, and I think this is what's going to complicate it. It's going to open you up to litigation. It's going to raise more questions. I know New Hampshire just passed a law on Tuesday that said pharmacies can host as long as they follow the DEA rule. That was that simple, and that's all it needs to be, is permissive. And if we start there, and as Tim said, there's not been problems. We just haven't seen the problems, that all the frightening stories that have come up, and we just have it's never happened. So if we just go forward with the simple thing, let this start get going. We've got an epidemic on our hands. We've got a lot of people that want this thing. So let's get it out there. And if you need to ratchet it up, go ahead and do it. You can always do that. But starting with this level of detail before we've even really explored this, I think it's just going too far.
So you're
that would be our
suggesting
suggestion.
to eliminate I as well?
Sorry?
You're suggesting to eliminate this?
Yes. Quite a few sections, actually, but this would be just the one I'm talking about.
Thank you.
Thank you.
Thank you.
Well, yeah, I think I is probably potentially going to be the most problematic. Were we to go forward as things are, and, leave I in, I'm not clear how this would then play out, when some local pharmacist said, well, in my opinion, there's a danger here, and then the locality says, no, that's baloney, there's no good reason, and then who decides at that point? Because if the pharmacist has a facetious reason, how does that get adjudicated and in front of whom? That, I think, is a gray area we're going to be leaving if we leave I in.
Well, I don't think, we're not saying here that if the locality mandates it, we're then saying they don't have to do it, are we?
Well, my for instance is, okay, I'm in a county, the county has passed an ordinance that says I have to have one of these things. I say, I don't like the color bins, and that did turn out to be an issue. Therefore, I don't want to have them in my pharmacy. That's a good enough reason. And then we're like, well, no, the county says that's ridiculous. That's not a good reason. That's not a safety reason. And then who ultimately then decides if it is a good safety reason?
In this
or
case,
not?
we are preempting the locality.
Well, I'm not even clear where this goes in terms of an education process. If some dispute arose like that, where in the judgment of the pharmacist in charge, they thought they had a good safety reason, but maybe it was a silly reason, who would rule on that?
Probably the local.
But the local entity would presumably take some enforcement action, and the pharmacy would defend their action.
Okay, so let's say there's a fine
some
attached or something like that, then the locality imposes a fine, and at some point it goes up and somebody has to decide, some judge.
Be some either
Okay.
quasi adjudicative tribunal or a true court. Yeah.
Right, okay, point is, though, we're leaving a gray area here.
Good
Why do
afternoon.
we want to subject ourselves to this?
You're not subjecting the board
We're
to
not,
that?
because this wouldn't be enforceable we're never going to go into a pharmacy and say, we got a complaint, you're not doing a take-back bin, why aren't you doing it? This would never be something, because our language is permissive, it says may. Good afternoon.
Well, I'm not sure about that, Amy.
As long as we're permissive, why do we need it?
The local ordinance, we don't enforce local ordinance.
Because by May, we don't mean to just have some blanket preemption, right? So, anyway.
Good afternoon.
Hi, I'm Bill Worrell, Manager, San Luis Obispo County Integrated
Bill.
Waste Management Authority, as with Tim, one of the two counties with mandatory programs. We were willing in our comment to compromise with this section where I think your attorney at the last meeting recommended it be changed to the collection receptacles could be not used if they can't comply. The reason we don't want it to be as broad as it currently was written is that any pharmacy could say, we cannot comply with the provisions of this article because we didn't order mail-back envelopes. So all they have to do is say, we don't have anything in store, how can we hand them out to public when they come in?
Your recommendation, I'm reading it right now, is to instead of deleting the whole section, add in 1776.3.
Actually, what you guys did on
Receptacles.
5-31 is fine with us, because you've made it specific to the collection receptacles. And I think your staff did a good job of solving that concern. But if you leave it like it was before it was changed, again, just by saying we don't have these mail-back envelopes in our store, we can't comply, would get any pharmacy off the hook. And, you know, we give the pharmacy options in our mandatory ordinance, either collection receptacle or mail-back envelope, because we understand there are maybe some situations they don't want to deal with a collection receptacle. So we built in that flexibility. With this, you're going to basically take that away.
Thank you. So what do you think about adding that in, is adding in 1776.3, which is what San Luis Obispo has recommended?
Or just
in there.
specify.
Yeah, just specify. So it would say, a pharmacy shall not provide take-back services to consumers as provided in section 1776.3, which if you look, says collection receptacles and pharmacies.
Or you can just use the word.
I'm on I still, on that PIC language, but I'm reading a comment from San Luis Obispo Integrated Waste. They recommended, instead of deleting the whole section, to changing it to just refer to 1776.3, which is collection receptacles and pharmacies.
Why don't we just
I think
insert
that
the
makes
phrase?
sense.
Why don't we just insert the phrase instead of 1776? It's collection receptacles we're talking about here.
Either way.
Otherwise, they have to flip back through and go to the code section and see what it
Right.
is.
That's the equivalent of the switch between, that was in the discussion draft, the do not provide take-back collection receptacles. It's the equivalent of striking out services and replacing it with collection receptacles. And I would agree with Ginny that I think it's clear just to say that
just say
if that's what
collection
you want.
receptacles?
If that's what the board wants.
Okay.
That's a policy call.
We have some public comment. Brian?
Well, so first, is there a motion to amend what was previously?
We're basically just discussing, I don't think we've even taken
Oh, okay.
the temperature of the board yet.
Okay, thank you. Brian Warren with the California Pharmacists Association. We do believe that the pharmacist in charge should retain the ability to say that there is a problem with dispersing mail-back envelopes. I think that there are health and safety issues here. In particular, one, if you look at one county that does have a mandate that includes mail-back envelopes, you have to provide those envelopes to consumers without any patient request anytime that patient collects prescription drugs from the pharmacy. That gives a very conflicting message from a pharmacist who's trying to encourage patients to take medications, that here is an envelope to take your leftovers home with, or to mail back your leftovers with.
Like assuming you're not going to take all your meds.
Yeah, there's either an assumption or an implicit, type of hint that maybe you don't need to take all your medications because every single time we dispense a prescription, here's an envelope. That was a policy that wasn't written with the healthcare provision or the provision of healthcare services to patients in mind. And a pharmacist in their professional judgment might determine that that's not in the best.
Do you have any evidence that anything like that has ever happened?
That
a consumer was given a disposal envelope, they, oh, well, I don't need to take my medicines? Really?
No, I don't have, there's no study that indicates it.
Let's let Brian finish his comment. Go ahead, Brian.
So we feel that is conflicting with much of what pharmacists are trying to do, with encourage patients to take all their prescriptions, to repeatedly provide them with envelopes for the purpose of mailing back extras with, when this consumer should not have extras. We also do, just reiterate the importance of retaining the ability for the pharmacist in charge to make this, that pharmacist in charge is under, with the Sternberg decision, under strict scrutiny for anything that happens in the pharmacy, even when they're not there and even when they have policies and procedures that address an issue. And I think that this isn't a matter of the board regulating the practice of pharmacy. But for, I think, some local governments having concern here, I think this is something the board would normally say, yes, we think that a pharmacist in charge should be able to make a decision like this. However, when you look at the issue, there hasn't been a shortage of pharmacies that have been willing to volunteer for programs when there have been actual take-back programs out there. Independent pharmacies have willingly volunteered to do these in Alameda County, in San Francisco. Walgreens just recently announced that they are doing this at numerous stores throughout the state. And the risk of the board preempting this for some pharmacies for which this does not work, the supposed risk is that pharmacies wouldn't do this, and we just don't see that as a reality.
Thanks, Brian.
Thank you.
Angie?
Hi, I'm Angie Minetti with the California Retailers Association. I'll be brief. Just wanted to also echo Brian's comments to restoring the language for broader take-back services. And part of that is because, with the mail-back envelopes, I think our folks have experienced low utilization rates with them. They haven't been returned. And I think what we're trying to do here is for the folks that do need it, that may have a surplus supply of medication in their cabinets or whatever it is, we want customers to be able to come to the pharmacy and request one and get one at no cost. Also I want to speak to take-back events too, because I think we've been thinking of disposal methods as far as kiosks and mail-back, but our members offer a spectrum of disposal methods available, whether it's the in-home disposal kits, whether it's take-back events, kiosks, etc. And so what our members have always emphasizes that if we do participate in take-back events, we do want to ensure that law enforcement is present. And I think our concern is if we only limit the PIC to make determinations for hosting a kiosk, then at what point are we going to be, potentially subject to some sort of policy that either requires us to hand out envelopes every single transaction or, hosting take-back events in places that we don't think are, appropriate to host a take-back event. I mean, part of that decision-making, and, our members do this every time we the DEA does their national drug take-back is, okay, well, do we have the pharmacy staff to be on site and be available, completely dedicated to running and managing the event that day? That's a consideration. Is law enforcement available to be there? And so, this has never come up, and I'm not, I don't know.
Thanks,
Yes.
Angie. we got to stay on track because we have a lot to go.
Absolutely.
I appreciate
Thank
your
you.
comments. Thank you.
Amy.
Yes, Victor.
I think in a democratic and a free market world, if it's a popular thing, it's a good program, you don't have to worry about people don't follow. And we shouldn't be worrying about and scrutinize on this minor detail because we cannot force even every registered voter to vote. You cannot say, I mandate you, if you don't do a walk-in, you have to do a mail-in. This is a free world. So there are always some people, they don't like to vote, even though
What's
they're
your
registered.
recommendation, Victor?
Recommendation is just leave it the way it is right now, and you don't have to worry about scrutinizing every
second.
single bit of it.
And do not put in anything about collection
Anything else
receptacles?
that you have to do a mail-in,
Just leave
you
it
don't
very
do this.
vague?
Yes, yes.
Okay.
Leave it
Is
up to
everyone
the,
okay with
leave it up to
that?
the pharmacist.
I'm okay
and
with that.
pharmacists to do it.
Amy, I wasn't here last meeting. On those mail-back bags, who provide, I mean, the pharmacy will provide, but who pays for them?
I'm not sure that's an issue that should concern
Well,
us.
as I understand, the meeting I was
A
here
safety
before, it
issue.
cost about $5 per each. Now, they don't even make $5 per prescription. And
I don't think we can argue that that's a patient safety.
I know, but who going to pay for it?
Yeah, I think the independent pharmacy.
It depends on the location.
Yeah, so.
Okay.
So we're going to pass on the suggestion
Yeah, I
from
think this one we should
Santa-
do a vote just because it's so.
Yes, let's do a vote.
Yeah. So I heard a motion from Victor, which is basically to keep I as it is. Now, Victor, what you meant is take out as provided in sections? Is that what you meant? So it should say a pharmacy shall not provide take-back services to consumers if in the professional judgment. Is that what you're saying?
What's the nuance of removing?
I don't think it has any impact.
No impact?
Impact, yeah, so we'll just keep it the way
We
it
can
is.
just leave it in there.
Yes.
Because, well, I think the
I would
nuance is
actually
that it does include the mailback.
It includes the mailbox, but as it's currently drafted, so does take-back services. So as long as they match, I don't think that there's an impact. I do think it's a little, it can create a little bit of confusion because it
Should we
implies
take
that
it
there's,
out?
because that, otherwise, what does that clause do, is the
Take out
question.
I.
So if,
Uh-oh.
I don't believe it has any value, so because it doesn't really add any value, I would recommend deleting it, but leaving it in, from my perspective, doesn't change the effect of the regulation. I would take it out.
Victor, are you okay with that?
That's fine.
And I second.
Second from Cheryl. Okay, any other board member comments?
Reference to the
Yeah, take out any reference to in sections.
76 to 1776.
Yeah, so it'll basically say services to consumers if in the professional judgment.
Victor, that's for I and J, correct?
Okay, any other public comment before we take a vote? Okay, all those in favor? Oppose? Okay, all right, let's move on. 1776.2, RX Safe Marin. Commenter recommended that mailers be pre-printed for postage because the public should not have to pay the postage. Now, staff said accept comment, prepaid postage is a DEA requirement. Is that true?
Addressed and pre-stamped,
That's a DEA requirement.
yes.
Fantastic.
There you go, Albert.
Man.
Okay, so we're going to accept
Alfred
comment, and we're
South,
going to be saying pre-printed on there?
Well, here.
It says pre-addressed right now.
Huh?
They're saying it says pre-addressed mailing envelopes or packages.
Yeah, it's in
You wanted to add
1776.2B. It says all envelopes must be pre-addressed, so we're going to add pre-addressed and
With
Couldn't we just
postage.
say-
pre-printed for postage.
You know, they're too-
It's 1776.2B. And it says must be pre-addressed to a location registered with the DEA as a collector.
It says that, well, it says all envelopes
But then that would be to that.
must be pre-addressed to a location registered with the DA as a collector. But they want us to add and postage included.
And postage paid.
Postage paid.
But they have to follow the DA regs anyway, don't they?
Yeah, so
Well-
that's what I'm saying. Just say according to DEA
Whichever is
regs.
more stringent, arguably.
What is?
Whichever is more stringent, but the difficulty with the DEA regs is that they're hard to read and comprehend. And so our goal in doing this was to put forth a regulation that was more clear than theirs, where you have to read across various code sections, and you can't even identify what's new and what isn't. It's difficult. So at least I found it difficult to read it.
If we add back in C and D of this section, it'll address the concerns.
Back
And
in
it
C
matches
and
the
D?
DEA, yeah.
What are we looking at here? I'm sorry.
Section C and D,
We're in 1776.2, which is entitled Mailback Package and Envelope Services from Pharmacies.
Well, C and D, you have it struck here, so,
yeah, if we add them back in, it'll match the DEA regs.
oh, all right.
Why don't we just do it?
So do you want to add on back in C and D, board members?
Okay, C says the prepaid, huh?
DEA reg.
I'm not very clear on it. Now, when they say mail back to DEA, you say all drug or just control drug?
This is all drug.
All drugs.
But instead of having a bin, a receptacle, you can have
So
mail
all
back.
drug
You can put
to
everything in there.
DEA.
No,
They don't go to
it doesn't go to the DEA, it goes
just
to
the
DEA
Prescribed drug.
Goes to a
collector.
location.
And this is still permissive, so if a pharmacy does elect to do this, Laura, they would, If they would, if they were going to give out envelopes, they just have to do the postage on them. Is that what we would be saying?
That's how I interpret that, yeah.
Okay.
Now, do we need D back in there? To contain a unique identification
No.
number and certain
We
instructions?
just need C.
Just C, add C back in?
D is a DEA requirement if you want to add it in.
A unique identification number?
Yeah.
Oh, that's in there?
That means you have to have it in your reg.
But it'll be required anyhow, which is, I think, what
Jenny's
the
saying.
executive officer's point is, if you put it here, then it's more likely to be complied
Because
with.
give them an envelope that doesn't meet the DEA requirement.
So put it back in, Greg, is that what you're saying?
Yes,
Add it back in C and D?
C and D.
Is everyone okay with that?
Is there any public comment?
Well, wait a minute, let's go to the next
We're
one.
not
Oh,
done, we're
all
not
right.
done with 17.6.2.
Well, before I say, yeah, I'm okay, I'd like to hear.
Yeah, let's go
Okay.
through all the
All right,
1776.2.
going on to,
So,
go ahead.
so what have we decided that
Yes.
we don't feel it would be just as beneficial?
Well, we're talking about it. I think Ramon asked for public comment.
Adjusted as to put.
They don't know what the DEA requirements are. They have to look up what the requirements are.
Now, there are some comments that say that we should say that the mailback envelopes meet the requirements of 21 CFR 1317.70C. Now, it says here, though, Jenny, and make them available for sale or for free. So does the DA require that the payment be through the
It's
pharmacy?
silent on how the transaction between the pharmacy and the patient gets consummated. So whether or not the pharmacy may have a grant to provide them, or whether or not the consumer has to pay for it, the pharmacy can sell them. There's nothing that the DEA, you don't have to provide them free.
But they have to include postage.
But the pharmacy doesn't have to pay for it, is basically what the DEA is saying.
If the DEA, I'm not aware of there being any
No, I think-
provision in there that requires the pharmacy to pay for it.
Debbie, read the top of that comment from LA County and LA Waste and San Francisco Department of Environment. They're recommending, say, utilize mailback envelopes and packages which meet the requirements of that 21 CFR and make them available for sale or for free.
Right, so that's exactly what I'm saying.
21
Right.
CFR, that's the DEA's requirement?
21 CFR is the federal
13
requirement.
Yeah, 1317.70C.
My only concern with specifying that section is if it changes, our reg won't be in compliance. So I don't
So if we
recommend
do, if we
including that
do what they
reference.
say, our reg's not in compliance.
Well, if, say, 5 years from now, they change this section.
Oh, I see, pointing to that reg.
Yeah.
Oh, gotcha.
Better off having the language.
So don't point to it, okay.
So what are you recommending, Greg?
Okay, just add C and D back in. Well, what do you guys think about this number A, register with the, so they're saying that this is confusing, and we should just say, the pharmacy needs to register with the DEA and the board. I mean, not the pharmacy, but register with DEA and the board as a collector. So do we require the,
They don't have to be a collector under subdivision 2. Point 2, or sorry, 1776.2 does not, to provide mailback services, they do not need to be registered as a collector.
Right.
they do not?
partner.
Do
They-
not.
A DEA collector, they do not?
They do not need to be a DEA collector
But-
if they're only handing out envelopes.
Can I ask you though, Jenny, to hand out an envelope, you don't have to be a pharmacy. You could be,
Anybody can hand out an
anybody can hand
envelope.
out an envelope.
Right.
So if you really want to look at access, that would be the way to go. Is just to have a lot of places handing out
exactly.
envelopes
Or-
that don't
or
have to be
selling
pharmacy.
envelopes.
Yeah.
So,
But I guess this is saying the collector, this is saying the collector has to be registered with the DEA and the board.
Yes, the collection, you have to.
If you've got a collection
Receptacle.
receptacle,
If you have
you
a
have to be
receptacle.
registered
Have to be,
with the
yes.
DEA and the board. If you're only providing mailback
Mailback, you
envelopes,
don't.
you do not.
Got it.
Unless that's mailed
That was
back to you.
in the prior draft.
Okay,
Yeah.
thank
The
you. So-
language was initially noticed
But
that
Jenny,
way.
unless it's mailed back to you, unless you put your address on there as the mail
That's a
back.
violation. You can't do that. Nice try, Amy. You better have a local means to destroy your
So
drugs.
maybe I could ask a question of our attorneys.
We're going to put Sandy in.
LA County and LA Waste and SF Department, is that San Francisco Department of Environment? Mm-hmm. So there's no numbers on the page, but section 1776.2.
Right, so so that's what I was just talking about. A, she
Okay.
said is, no, that's not true.
Well,
We don't
I
need
think-
to do
Okay,
that.
here,
Let's let Stan finish.
So under B, it says utilize mailback envelopes and packages which meet the requirements of 21, et cetera, and make them available for sale or for free
Yep.
to the public directly or through another entity, including but not limited to other pharmacies. So how do we have divergent opinions on whether or not they're for sale or for free with regards to LA County and then others who say that the DEA requirements are, that they are for free?
The DEA actually doesn't, the DEA's response to their comments, I read through them with this comment. The DEA states that they can either sell them to the consumers or they can offer them for free. They do not have to
Someone just
give
said that
everybody
they
out.
were, okay, then I missed that.
They have to be pre-addressed. They
yes.
have to be pre-stamped.
I understand that,
you
but I thought that we were
charge
talking about
essentially- yeah.
that there was an expectation that they be given away, or that the option is only to give them away.
No.
No.
So what about postage? Is that an option?
They have to be pre-posted. So they have to have
prepaid,
stamp, yeah,
But you don't have to give them away.
correct.
Okay. So,
So what do you recommend, Stan?
well, so
It is
I
in the
think if
text.
that's the DEA, and I'm sorry if they change it in 5 years or in 10 years or if they never change it. But I think this refers specifically to the DEA and what their current requirements are. And I'm fine with their current requirements. And if it changes, some of us will probably still be on the board in 5 years.
Hey, Stan, but look at what C says. I think it just says it without the reference to it says the postage shall be prepaid on each envelope or package.
Hang on, let me find C. I got it.
So it says the pre-addressed envelope and package must be water and spill-proof, tamper-evident, tear-resistant, sealable, the exterior nondescript, not including any markings that indicate the envelope or packages contains prescription drug. Postage shall be prepaid on each envelope or package.
Okay, that's good.
That came out of the DEA.
Okay.
That doesn't say, though,
I think
whether
that's
it's
better
free
than,
or
I think
sold
that's
or-
better than this B suggestion, is all I'm saying.
Just a little clarification, I pulled up the law, the federal regulation, and it actually does say, collectors or law enforcement that conduct a mail-back program shall make packages available, open paren, for sale or for free, close paren, as specified in this paragraph to ultimate users and persons lawfully entitled to dispose of an ultimate user's decedent's property for the collection of controlled substances by common or contract carrier. So it actually does reference that for sale or for free in the reg.
Do you want to add that in there?
I'm good. No, I'm good. If C covers it adequately, I'm good.
Good afternoon.
Hi, good afternoon. I'm Maggie Johnson from the Department of the Environment in San Francisco. So I just would like to clarify that comment. I think it wasn't maybe quite clear. What we were trying to get at is that the DEA actually distinguishes between a pharmacy which operates a mail-back program, meaning that they receive the packages back and have to have an on-site method of destruction. And then from the DEA's perspective, they, as you mentioned, have no real restriction on who distributes the envelopes. And so there was, I think, a header sentence before the A, B, C, D on the first part that sort of said 4 pharmacies that are operating a mail-back service versus the 2 or whatever it was, sorry, I don't remember.
Right, it says-
Just distributing envelopes.
Yeah, A says as a collector.
Right, right. And I realize that in California, it's probably kind of unlikely that a pharmacy is going to have an on-site method of destruction, but life is long and who knows what could develop. So that was the intent of the comment.
Your comment is actually into G, because G basically says a pharmacy shall not accept any mail-back packages or envelopes that contain drugs. And your point is unless they have an on-site method of destruction.
That's what the DEA allows.
So we probably need to add that in there as well.
Then they have to become a collector.
Yeah, unless they're registered as a collector. I think,
And have an on-site destruction.
yeah, because if we're going to be doing these regs for a while, you don't want to have to update them in case, you're right, some pharmacy decides to do it.
Since you're from San Francisco, can you tell us how the program working out?
Well, we have a pilot program that has been in place for about 4 years, and that was a program that was developed and established before the DEA regs came out. So we have 12 pharmacies and 1 community center that collect only non-controlled substances, and then in our pilot program, the controlled substances have to go to our police departments, all of which accept them over the counter, though. They don't have bins. The ordinance that we passed in 2015, and which is in the implementation phases, changes that quite a bit, and it requires any pharmacy that accepts any medicine to collect both controlled and non-controlled substances now that the DEA rule is in place and it's allowed. So it's going to change quite a bit. We've received our plans and we're in discussions with the pharmaceutical industry about their plan and the specifics of it. It's, I'd say, about 80% there. So we're hopeful that by the end of this calendar year, if not earlier, that we will have multiple pharmacies. Our goal is 55 pharmacies throughout San Francisco.
Are they voluntary or mandatory?
We currently have no mandatory requirement.
So it wasn't a need for mandatory for that, right?
Well, we honestly don't know yet. Like I said, we're still in the implementation phase. We have, as you mentioned, good indications that a lot of pharmacies want to volunteer. However, in San Francisco, we have about 135, I think, don't quote me on that, retail pharmacies that are registered, licensed by the board. 66 of those are Walgreens. Walgreens is currently, has opened 5 bins that accept under a private program. And the indication currently is that they will not do any further. So, and we also have several other, much less number, of course, 8 or so CVS and, some of the chain pharmacies. We would like to be able to keep it voluntary. San Francisco agrees that it's not appropriate for every pharmacy. There may be pharmacies that can't meet the DEA requirements, for example, for whatever reason. But our goal is to have a permanent and sustainably funded program that's convenient for our residents. And we believe that less than 55 drop-off points, and we believe pharmacies are much more popular with residents. I mentioned that our pilot program has had police and pharmacies, but we find that most people don't really like to go to the police department. Only about 5% of our medicines by weight that we've collected are come through the police department. So
Feedback, it's a positive feedback from the consumer, right?
yeah,
Test.
exactly.
Thank you for your comments.
But I do have a question also. We've been talking about C and D for some time. Do you know what we're talking about here, and do you have any comments?
Oh gosh, refresh my memory. I'm sorry.
Oh, this was
The envelope requirements.
the envelope
The fact
requirements.
that they be water and spill-proof, tamper-evident, and they be pre-addressed.
I believe those are all DEA.
Yeah, I see thing, right?
No, we're talking about C and D, the envelope requirement, which we're talking about putting back in.
I believe those are all DEA requirements, and it would be, as long
So
as
it's
you
kind
say.
of moot
have
from
to-
your point of view. You have
yes,
to do it anyway.
Exactly.
Okay.
Exactly.
Thank you.
Thank you.
All right, let's move on to 17, unless there's any other public comment. Let's move on to 1776.3, which is collection receptacles and pharmacists. CRA recommended that written log be removed for alternative record-keeping systems, and that's in, trying to find out where that is. I didn't specify the letter.
Down below, yeah, I'll find it just a second. Written log, it's in I.
I, see 1776.3I. So you want to take out written in a log?
Well, what kind of log do you have if it's not?
Well, it could be electronic. I think it's the
Why don't you say
same.
electric?
Remember we dealt with this with sterile compounding as to whether it's written or it's maintained on a computer?
So if we just say log,
Yeah.
it'll be mean,
Log's
It's
good. Take
a,
out
what if
written.
it's a memory log? Where they just-
Doesn't count.
Okay.
I mean, you could just say written or electronic. It
Or
seems like,
just, not, just say log. I mean, isn't log from our attorneys, is that clear enough if we just say log?
I was making notes about our last comment. Which page are you on?
We're on I, actually, on page 5 of 11, right towards the bottom.
Amy, I got a question. Now, in Alameda County, like say, we already had the program. If I sign up with that program, do I exempt from the pharmacy? I mean, don't have to go through, right? The what they have, I think somebody come and collect for them, so they don't have to do anything. So they don't involve any employee or anything. So I would prefer that way. So if I would do that one, so I don't have to do this one, right?
It's all voluntary.
Yeah, I know. I mean.
And Alameda, it's voluntary too, isn't it?
Yes.
Yeah.
It's a volunteer.
I'm sorry, was the question whether a
Whether
written log
written-
could be electronic?
Whether removal of the word written means anything. If it just says in a log, do we have to have the word, and remember we dealt with this with sterile compounding too.
Right, no, well, I'm not sure, but what I'm asking is, are you worried about whether this would preclude or allow electronic forms
Right.
of?
That's a
Can
concern
you-
we got from CRA.
I mean,
They
I
were-
think either way, it could be done electronically. If you
Okay.
wanted to make it slightly less, of an obstacle doing it electronically, or make people less concerned about it, you could remove the word written and just say in a log.
Let's just remove the word written, yeah. Okay. Okay, the other recommendation from CHA, they recommended that verbiage should be added to explain what should occur if the deposit of inappropriate items is observed by staff and observed while transitioning the liner out of the receptacle. So if they're taking the liner out and they see syringes or something inappropriate, are they supposed to do anything? I thought they were supposed to inspect it.
They're supposed to pull it up and seal it, and
Right.
that's it. They're not supposed to
Supposed to do
dive into
anything.
it. They're not supposed to do anything other than seal it when it comes out of the bin. It's not intended for them to become liner police. They don't, and then what do you do with it once you pull it out?
Okay, and then the next comments are
can
regarding.
I just add one thing, Amy? Written is also in K.
Okay, so we'll take that out as well. Is that okay with everyone? Okay, and then we're going to, the other comments we got is regarding the fact that we need to have the physical, something to block the area where the receptacle is housed. And the recommendation is that we remove.
Can you tell us what page we're on? I'm sorry.
We're on 1776.3A. So it's towards the end where it says the pharmacy shall lock the deposit slot on the collection receptacle and physically block the public. So can we take out that physically block the public from the collection receptacle by some means? Some of the commenters at our last meeting were saying, well, if you put up a wall, they're just going to put stuff outside the wall, which makes sense. So
Yeah.
can we just remove that?
Yeah.
Okay, is
Well,
everyone
there's a lot
okay
of
with that?
So we're
A lot
taking
of
out
comments
what?
about that.
And physically block the public to the collection receptacle. Now, the locking of the bin is a requirement from the DEA? Yes, okay.
It's just
The slot.
It's
The
just
slot.
a physically blocked
I would
on
think
part.
leaving it open would, I mean, if you're looking at safety, at least,
Well, that's basically the same.
I think the
thing.
recommendation is just to take it out.
And take out the rest of the sentence.
Yeah, just take out the rest of the
So it's
sentence.
just going to say pharmacy shall
Yeah, that
lock
makes
the
sense.
deposit
The
slot.
previous sentence already says it's
Period,
inaccessible.
right?
Yeah. So and it does require you to lock it, because I would assume if it's like a mailbox,
Get rid of the physical
it would be
block.
better to keep it open so you could at least be putting things in.
Well, they require it locked. That's all I'm saying.
Okay.
So the board can choose to go, I suppose, a different direction. I just don't know what that does if the DEA comes in to take a look.
Well,
Do you have something?
Aren't we saying that, Amy, we're leaving in the pharmacy shall lock the deposit slot of the
No, the
receptacle?
comment I was making that is if we're going to have this bin like a mailbox, and we're going to lock the mailbox when the pharmacy's closed, they're going to put things outside the mailbox. So to me, it would be safer if they just left it open and you put it in, because you're going to go there anyway. At least put it inside the bin than to leave it outside. Just my 2 cents.
Pharmacy was going to be closed.
Want to put his,
How would
okay,
you
we're,
be putting it?
They may, well, some pharmacies may be closed, but the collection bin would still be accessible.
But Ginny's saying we have to keep it locked because of
Well,
DA. The
I think I'm about to hear something else here.
Thomas Hare, a staff member for the city of Santa Rosa. Hello, everybody.
Hello.
It seems like it's controversial what the DEA is saying. There's been some email interaction with Ruth Carter, who was the chief of their.
Yeah, they've got somebody else doing it now.
Yeah. And she had indicated that it did not need to be locked in that email communication. So I think it's a little bit uncertain. They do definitely say locked or made inaccessible in certain places.
Exactly.
So certainly if the pharmacy is closed, it shouldn't be, and it's an independent pharmacy, it shouldn't be required that that bin be locked inside of a closed pharmacy.
But if it's in a clinic area or a hospital, and it would be better that it be open so you can
I
at least put
completely
stuff
agree.
inside.
And that's what Ruth Carter said, is that they recommend not locking.
But can
the
we
receptacle.
clarify this
So-
with the DEA?
Well, the DEA regs does say locked. Lock the slot.
But do you have something in writing from them that you can share with
There's
us?
an email from Ruth Carter, but
You're going counter, you've got what I say versus what the pharmacy law says. I
think
carry
in
no weight.
responding to the comments, they addressed
No,
that,
carry
and they specifically, in the written comments that are part of their final rulemaking record, I seem to recall reading very explicitly
It's explicit.
that they want pharmacy staff to be able to not necessarily observe every transaction, but to be in the area so that they can monitor, or just that they're.
And where they don't do that
And
is
they-
in the hospitals. It's just
and
in an
they
area that's accessible.
specifically didn't want it in other areas of the hospital. That was also very clear in their responses to comments.
that it would be, yeah, if it's not being regularly monitored by employees, that it should be locked or made otherwise inaccessible.
But
Would be,
by pharmacy employees, they were very specific.
not by my interpretation of certain sections. Certainly with the long-term care facility section, there was I know we can, that's a little bit later in this section, we can get to it. We can talk about it now if you prefer.
Okay, well, I didn't look specific at the long-term care facility. That's not what's coming to mind. Mine's coming to the,
Well, that's part of the reason the regs are difficult to read. They're all over the place. It's hard to follow them. So the board's got to decide what it wants to do.
Thank you.
Yeah, actually, what they wrote up here is actually pretty good. And their suggested proposed changes, the collection receptacle shall be locked or made otherwise inaccessible to the public when not being regularly monitored by employee, so that the drugs may not be deposited. And so they kind of go on, I think what he was just saying is that this Ruth Carter indicated that, like in a chain store, the pharmacy might be closed, but if the rest of the store is open and there's employees that can see it, that maybe, that they understand from the DEA that that would be okay.
Employees or pharmacy employees?
Store employees.
So you can actually have in a grocery store, have grocery
Just say
store
that the
employees
DEA
monitor the bin?
She further stated that the DEA makes no distinction between the pharmacy department staff and the store employees as in a registrant pharmacy when it comes to who can manage the kiosk.
Okay.
I mean, I don't know if we, this is one letter, one.
Well, staff come and go, and you've got the law in the books. That's.
Yeah, and
the
I'm
difficulty
going to
the
listen to
board's
our
got.
attorney here.
I will certainly re-review that provision and bring you feedback on that topic in July.
Thank you.
But
Well, and I'm looking at it right now, and it says it should be locked or made otherwise inaccessible to the public when an employee is not present, e.g. when the pharmacy is closed.
Right, it says that.
Okay.
Hello.
Hi. Like the last speaker from Santa Rosa and Santa Cruz County, we also sought clarification from the DEA on these sometimes confusing regulations. And we received the same guidance. We have locations where a pharmacy within a medical clinic does not have space within the pharmacy for a take-back bin. And so the bin was placed nearby on the clinic area, and it's supervised by clinic staff. We're always careful to make sure bins are where employees can oversee them, but the guidance we've received from the DEA is that those don't necessarily have to be pharmacy employees, although I acknowledge that sometimes the regulations seem unclear. Similarly, in pharmacies that are located in larger stores, the CVS's, the Rite Aids, the Safeways. We have bins that are located in publicly accessible areas. Sometimes the stores are open longer hours than the pharmacies are themselves. They generally do not lock the bins. Public comes in at all hours of the day and night with medications to dispose of, and they feel that it's safer and more appropriate, as you said, to let them put it in the bin than to possibly leave it on top of or in some other inappropriate location.
Bins are like mailboxes, so you can't get
Yes,
banned in there?
yes, exactly. These are heavy gauge steel bins bolted to concrete with chutes that do not allow you to put in a hand or any kind of device. They're designed to be tamper-proof, and they work very well. In the interest of resolving this, may I suggest that you just refer to DEA regulations and perhaps ask staff to take some time to maybe get written guidance from the DEA so we can all work off of the same rules instead of these impromptu
Thank you.
conversations we're having. Thank you.
Thank you. All right, so we'll have Laura investigate. We have another public comment?
Hi, I'm Bill Pollock from the Alameda County Household Hazardous Waste Program. I'm been mentioned a lot, at least my program has been mentioned a fair amount. I'd like to talk to you. I know I've been watching you on the meetings. I just want to point out 21 CFR 1305 defines what an employee is from the DEA perspective. It doesn't necessarily have to be a pharmacy employee. I think we're having a problem here conflating. We have the term pharmacy, which means the place at the back of the drugstore that dispenses the dangerous drugs, and people think the whole drugstore is the pharmacy. What I'd like you not to do is preclude the idea that when no employee is present and the bin is locked, you can put a sign on the bin that says, go to the customer service counter and get a manager to come back to open the bin for you if someone comes in after hours. When you're drafting some of these regulations, you're going past where the DEA stops, and you're precluding some actions like that. I think that
So the bin container the keys to that can be managed by someone other than the pharmacy, is what you're saying?
Right. An employee of the store is what, if you look at 21 CFR 1305, that's what.
That bin allows them to open up the whole.
Yeah, there's a flap on top, or certain bins are different. There's a padlock. At the Walgreens, there's a hasp and a little padlock. At some of the other bins, there's another kind of, there's a lock at the top. But there's a lock to lock the flap, and it needs to be locked when no employees are present, when it can't be observed. But there's no reason why you can't call a manager over who can observe it and open it up for
Thank
someone
you.
wishing to
And
drug.
this is just for the purpose of putting the drug in and then you
Right.
close it up.
After hours when the store is open but the pharmacy is gone.
Thank you.
I think that's important because it's otherwise the customer would just dump next to the box, and that's even worse for us.
Okay, I think it's 4:30, and we've got quite a lot still to go. So if we can just go through and listen to public comment and finalize this. Good afternoon.
Hi. I'm Nan Braesmer, and I'm president of the California Alliance for Retired Americans, and we are one of the organizational sponsors of Senator Jackson's original bill dealing with this issue. And it's really gone on way too long, and we should have had this implemented years ago when the bill passed. But beside the point, I would suggest, because you're digging a bigger hole and a bigger hole and a bigger hole, and I've only been here today. But I would suggest that you support this program fully and encourage the pharmacies in our state to participate and let the counties work out how they do it. The counties that are doing it now are following the DEA regs, which seem to be as confusing as the ones you're trying to write, so everybody should handle that okay. And implement it within their county as what works best for them, instead of trying to cover every instance that you might think of that in LA it won't work, but in Shasta it will, kind of thing, which is what it's beginning to sound like. And let the pharmacies and the pharmacy chains work it out with their counties as to how they can do this. And we appreciate your support, but we'd like to get this show on the road.
Thank you. I don't believe right now there's anything precluding a pharmacy, and Ginny, correct me if I'm wrong, that would like to participate as long as they follow the DA regulations, they don't have to wait for our regs.
You don't have to wait for us.
So if there's anyone that's pressing that would like to start this, they can do that with the DA regulations.
Lori Hinsek, Kaiser Permanente, just really quickly, on 1776.3A, just a suggestion, that sentence says that the pharmacies may establish a collection receptacle in the pharmacy. I know we've had considerable discussion earlier in this meeting about licensed space and not. I know that in the pharmacy likely could be interpreted as meaning behind the pharmacy counter. If the purpose of this is to allow the public to have access, you might.
Out in the pharmacy?
I agreed.
Yeah,
Or
let's
even the
take
whole
it out.
sentence, to be honest with you, because it's repetitive with some of the information that's already permissible in 1776.1A. So just either, I would recommend for clarity, take out in the pharmacy or take out the entire first sentence.
The licensed premises that you can't have the collection bin in, it's outside the pharmacy per se. What the public considers as pharmacy is the whole walls around it, but the licensed premises is where that gate comes down and the counter beyond which you do not go.
Right.
That's the actual license.
Except for a hospital, where you can actually have it anywhere.
Well, are
as
you
long as
talking
you're not
about
by
an
the
outpatient
urgent.
hospital or an inpatient
As
hospital?
long as you're not near the urgent care or the emergency room, you can have it in the lobby of a hospital, right?
Right, that can, yeah, exactly.
So that wouldn't be in the pharmacy. So I think that's a good suggestion, is just
Yeah.
take out in the pharmacy.
Especially because a later subsection of the regulation says that it couldn't be near the licensed premises. There just might be some confusion between those two, so.
Yes.
Thank you.
Yeah, and I think let's move forward. I think we're going to lose a quorum soon if we don't move forward. Okay. So the other comments are regarding, and we'll research, Laura's going to research the locking, that the DA does not require the receptacle to be visible to pharmacy employees and requested this requirement be changed. Is that a requirement, that there be a visible to the pharmacy employee?
In part, why you have to lock it when the pharmacy's closed is because you don't have a pharmacy employee around to watch.
Well, I think that's the comments
line
that's what I think Santa Rosa, Santa Cruz, and Alameda were just saying, is that the definition of employee, whether it's a pharmacy employee or not, is what we need to have probably reviewed.
So can we research that too, Laura, the definition of employee?
Very specific in their regs.
But we're making these rules for the pharmacy? Are we making these
Yes.
rules for the
Is
pharmacy?
everyone okay
or-
with
or
removing
based
the-
on the county?
Within the pharmacy, we can remove that? Is everyone okay with that?
Yes.
Okay, Cheryl, did you have a question?
Yeah, I was just trying to understand, we are talking about the bins that PICs are going to be responsible for, correct?
Yes,
Okay.
yes, not the other ones.
That-
Can you
that's
tell me
what
the
it
page
sounds
number
like
we're on,
we
please?
are talking about
4
the
of
other
11.
ones.
Still at the beginning. Okay, let's move on to, I think we've dealt with all of the receptacle. Is there any other member of the public, because I think we're getting late in the day, that has not yet spoken, that came to speak and would like their 2 minutes to provide public comment? Okay. Oh, there's someone there? Okay. No? All right. Okay. 1776.3H, which is talking about the US DOT standards exceed DEA requirements and are overly burdensome. Yeah, this is about the liner. We had a lot of discussion about liner. And that's a requirement, I think you had researched what the requirements for the liner are.
I have the Department of Transportation memo, actually, that requires it, and I understand they're talking with vendors that are going to be moving liners that have been removed from collection bins and work that out. But that, if the requirement is if they meet the DOT's requirements for this, it'll solve the problem without us being intricately involved with how that works out.
So are we okay with just keeping it as is on the liner requirements? Because the recommendations are that we remove those. Okay. And then also, they asked for removal of the words medical waste, transport of medical waste on there. But that's just the standards, right? That refers to the standards? It doesn't mean they're transporting medical waste.
No, and I think that there were a number of people that deleted that, so The issue there is whether or not you're actually transporting medical waste, which the argument will be is it is not medical waste, it's household pharmaceutical waste, or whatever the definition is, the actual term of art is.
Which number, which
I'm
comment is
I'm looking on
medical waste?
1776.3H.
And
There's
which-
recommendations about
Whole
removing
series.
transport of medical waste and also the USDOT. Hello? Keep
Hi.
it down to 1 minute, please.
No, I'm just waiting for the, I just feel
Oh.
very strongly about the medical waste. I wanted to hear what you guys wanted to say.
Oh, do you have a comment?
I'm sure that I will. It's not medical waste. If you
Yes.
make it become medical waste with this, it's going to be very challenging.
Delete it, yeah, I
So
hear
please
you.
delete that.
Just delete the medical waste piece.
Is that okay?
Yeah.
Okay, so we'll
So
remove,
all rigid from there on, we're deleting?
No,
No.
just the medical waste, which is, falls at the end
after
of the sentence.
transportation.
Okay,
So we'll take out for medical,
medical
for
waste.
transport of medical
And it's
waste.
in there a couple of times.
So we'll take out is everyone okay with that? Okay, moving on, it talked about the 2 employees of the pharmacy be permitted to supervise the removal of the liner. This is City of Santa Rosa. They recommend that the liner may only be removed from a lock collection receptacle either by 2 employees of the pharmacy or under the direct supervision. I think this goes back to what Laura's researching, is what is the definition of an employee for the DEA? Okay, going on to I, San Francisco Department of Environment requested the 14-day, I'm sorry, go ahead.
That one's, sorry, Thomas, City of Santa Rosa. That one's actually slightly different than the employee definition, but I think Bill can speak
Okay.
to that.
Okay, so.
All right,
DEA regulations actually, 1317.75, allow the inner liner to be removed by employees or performed under the supervision of at least 2 employees. So the pharmacy employees don't have to pull the box out, especially in programs where there's a vendor coming in, a licensed reverse distributor coming in, like Stericycle, who have their 2 employees. In situations like that, like the program in Alameda that's morphing into will happen. The pharmacist has to do is have another employee there and open the box.
and not pharmacist, but it's pharmacy employee. So
Pharmacy
it could be a
employee, right.
technician.
Pharmacy employee, you're right.
Okay.
Employee, open the box, 1317 or 1305 employee. All they have to do is have them open the box. As long as it's a licensed reverse distributor that's a DEA registrant that's licensed to do that, they can pull the inner liner out, seal it up, do the paperwork, and hand it to the pharmacist. I think this is another example of when you go beyond the DEA regulations, you start having unintended consequences. So I
So they
think,
can witness it or
right,
do it
cor-
themselves.
Right.
Okay, thank you. Witness
So we
or
just need to-
remove.
Yeah, so they
That's
have-
on I, that's.
So that's under I.
I3.
And they have actually a suggestion, or under direct supervision. I don't know if that's what you want to use, but.
Yeah, or under remove or under direct supervision. That sounds good. Is everyone okay with that? Okay, moving on to 14-day storage requirement under San Francisco Department of Environment. Under I, we have a 14-day storage requirement. They're saying remove that. What does the DEA require?
They require promptly.
So we define promptly as 14 days?
We initially had 3, there was pushback to 14. The comment is that's better than 3. What we find now is, we walk into pharmacies, we see outdated drugs, and it's a problem we've got. This has nothing to do with drug take-back, it's just that in pharmacies, they have outdated drugs frequently on the shelf. For us to have even 1 day, we remove it. We're using 14 here so that
So what do you want to do, Board, on the days? Do you want to keep it at 14? Do you want to change it to promptly?
There was concern that promptly wasn't
What do you recommend, Laura?
clear.
I think the words promptly and immediately tend to be flag words at OAL. So I think if you're going to require it, you need to specify what that means.
I think we leave it 14 like we have.
Okay. Is everyone okay with that? Okay, and then what about logging unused liners? They are saying that that should be removed because it serves no useful purpose.
Take care of it, it doesn't
You
matter.
okay with that? Remove that?
Until you use them is when it really becomes valuable anyway.
That's K1, right? Okay. All right, commenter requested the okay, 1776.3 K5. They're saying commenter requested the requirement to have a driver sign to transport the liner to the reverse distributor as some common carriers do not permit the drivers to sign. They want to remove the signature of the driver.
That's very true about
Get rid of it, yeah.
So can we get rid of that?
We've got other things.
Okay, so that whole last sentence goes out?
No, just the drive, I think it's
The
just the driver.
signature? Okay, the signature of the driver goes out. Right. 1776.3M, City of Santa Rosa. They want that the signage, the collector and receptacle shall primarily display a sign indicating that only Schedule 2 to 5 controlled and non-controlled may be deposited. I thought we took that out. We took out, the signage is only going to talk about sharps. So that's resolved, right? Okay, we talked about the list of drugs. Okay, 1776.4A, comment or express concern about the limitation with skilled nursing facility personnel. And requested that the language be modified to add mail-back envelopes and packages may also be provided to residents in assisted living retirement communities for the elderly in accordance with DEA 1370, to allow assisted living and residential care facilities to participate.
Deal with that under.
Yeah, that doesn't involve pharmacy, does it?
No.
Okay. All right, 1776.4.
On 1776.4A, is that where you're at?
Yeah.
I would actually recommend maybe just deleting that based upon a request by the resident patient, because the determination about who can authorize that release is made by somebody other than this board, and presumably you also, it's not just the patient, but it
You have a
could be
power
a
of attorney.
Yeah, it could be.
So just delete which part?
I would just delete the based upon a request by the resident patient, and then that leaves it to the skilled nursing facility to be responsible for that
Okay.
determination.
Is there a
right?
danger there potentially of employees of the skilled nursing facilities taking controlled substances away from patients and saying they disposed of them in an envelope? Because there'll be no records for that, it'll just disappear.
Well, so are you suggesting that there should be a
I don't know what I'm suggesting,
record
I'm
of
just
it?
saying that, like I said, I just am throwing that out there for the board, if it's not an issue for the board.
My
we can move
concern
on.
with the language as it is I remember seeing specifically in the DEI regs that there's a discussion about the ability to take a decedent's drugs.
That's 3 days and.
Right, but this doesn't, this language doesn't capture that, so either we need to match it with what that could do, maybe we look into that and come back with a recommendation to the board.
Okay.
Why?
If we need to have anything in there at all.
Yeah.
It's okay with, so we're going to delete based upon a request by the resident patient.
But we'll reevaluate if there's a need.
Okay, let's jump to 17, some of this stuff is about again, about the transport liners and such, the rigid containers, or the DOT requirements, which we already talked about. 1776.4N, City of Santa Rosa. Liners may be delivered to a reverse distributor's registered location by common or contract carrier pickup or by reverse distributor pickup. And staff recommended to accept this comment. Is that okay?
Wait, I'm,
What
On
page,
N.
I'm sorry.
We're on page 8 of 11.
Okay.
So it's 1776.4N, the City of Santa Rosa,
I'm sorry, what did we do about H2?
H2.
Sharp
I thought we
sandals?
decided to keep the Department of Transportation. We're going to take out medical, for transport of medical waste, like we did
Okay. Right.
before.
Okay.
We're just going to mirror what we did before. That's why I didn't go into that. Okay, and then, so we're back on N. So on here, they're saying that liners, that this section differs from DEA. Recommends the language be changed to liners may be delivered to a reverse distributor's registered location by common or contract carrier or by reverse distributor pickup.
That's correct, that needs to happen. That's how
Okay,
it needs to read.
so we'll accept that change? Okay, so we're going to change and accept that comment. Okay, and then 17.6.40, comment or express concern that record-keeping requirements are not specific enough and need to be modified. So there's more record, they're actually requesting that we expand on the record-keeping requirements. and add in date, unique ID number, and size of each unused inner liner acquired, installed, removed, etc. Board staff is recommending to accept that. Are we okay with that?
That point
Okay.
4.0?
Yeah. Oh, we're almost done. 17.6.5A, Sharps. Commenter expressed concern that a reverse distributor is only registered as a collector for mailback services and not for liners. So they recommended that the language be changed on 17.65A. Are you okay with that, Jenny? I think we said accept comment. Is that okay? Okay, board?
Yeah.
All right. 1776.5E, City of Santa Rosa. Commenter expressed concern that the language references incineration. However, incineration is not required by the DEA. They said to change that to destruction. Is that okay? Okay, 17.3E. I see destruction on our copy, so it's
It
maybe an
says
old
each reverse
comment.
distributor with an incinerator site, so it's a destruction site.
We shall maintain a record of the destruction, though. It doesn't say incineration.
You can't, destruction is the term to use, not incineration. It doesn't
Take
specify.
out the destruction site?
And replace it with.
Can we just say each reverse distributor shall maintain a record of the destruction?
Yep,
Yes.
yep.
Okay, take out with an incineration. Just take out with an,
No, we're
no, we're gonna
taking out
take
the whole
out
section,
with
that
an
whole-
incineration site.
It's gonna say distributor and then go to shall.
1776.6, San Francisco Department of Environment recommends that there are no records specified following the beginning statement and requests that the language be changed to all required records. Yeah, because we took out all the records. It says the following records for 3 years, then there's no records. So we just say all records? Is that okay? All required records? Instead of
No,
the
they're actually
following?
listed. They're listed, that's 1 through 5.
Oh, they're down here?
Yeah.
Okay, so we still want to keep the following? Okay? So we're going to reject. 1776.6B and C, Kaiser expressed concern that the language remove the unique identifier requirement for mailback envelopes, but reverse distributors are still required to record it. Additionally, Kaiser states that DA regs do not require a unique identification number.
Our staff says it is required.
It is required.
It's a requirement.
Yeah. It's a
Okay.
DEA requirement.
DA, so we're going to reject that comment. Okay, City of Santa Rosa, the method, they express concern that the section differs. This is 1776.6D1. The language should be changed to the method by which the liner was delivered to the reverse distributor, e.g. shipping via common carrier, reverse distributor, pickup. Staff recommends accept comment. Is that okay? Accept. Lori, taking good notes, right?
We've got a tape to help us.
Okay, San Luis Obispo Integrated Waste, the board does not have the authority to regulate pharmaceutical waste. Okay, that's nothing we're going to address. Legislative amendment. Then there's just some overall comments that you can read on the last page, if there's any that the board members believe we need to discuss. They're all rejected by board staff.
So is there a reason, I mean, this clean water action, it says that it's only limited to prescription medication. Is that a DEA thing, or?
Technically, the DEA requirements apply only to entities that take back controlled substances. Their regs only pertain to controlled substances, but patients don't know what controlled substances are. So in California, we've been waiting for the DEA to do their regs so that we could see what the DEA wanted, knowing that if you take back a controlled substances only program, or if you say no controlled substances program in a bin, you're going to end up with controlled substances in there.
But these are talking about OTCs.
Well, the issue is that I think the local communities want OTCs to be taken back. That's one for the board to decide whether or not we say prescription medication only, or do we just say prescription medication, knowing that some additional items are going to show up in there? We don't have anyone monitoring the collection bins, so there's really no way to keep it out anyway. I think it's just a statement. I appreciate their statement, but the reality is unless you station someone over the collection bin, it's going to happen.
Any other remaining comments from any of the board members?
Yeah, I have one.
Yes, Dan.
I want to thank President Gutierrez and staff and everybody for going through this process and leading the board line by line through this document, because it's very important to the board, very important to the consumers of California. So my hat's off to you, and I thank you very much, and you too, Jenny.
Thank you, Stan.
Thank you very much.
All right.
I also have a comment.
Go ahead.
I want to thank all the county officials who showed up here. It definitely brought, a good collaboration, I think, between the board and the experience that we already have. San Luis Obispo, Alameda, Sonoma, San Francisco, and I think Santa Cruz was here a while ago. Everybody must have made a special trip, and I think it was very helpful. And I hope also when we set our meeting for July to finalize this, that maybe, because I don't know if it helped the people coming from all over California to get here, that we didn't do this until after 12 o'clock. Maybe it did, or maybe it didn't matter. Okay, because then people could just drive up here. So maybe when we come back to this again in July, we try to schedule this item for the afternoon so that we can, again, have the advantage of the experience of the counties that have actually carried out these programs. I think it was for the people who were here. Yeah, they're all thumbs up. Yeah, because, Northern California, they all drove up. Sometime they got up there early this morning and were here by lunchtime. Okay, thumbs up.
Thanks, everyone. Meeting adjourned.